Welcome back. This is part 6. What are the results of your comparative analysis? What are the advantages and disadvantages of the CISG and the Swiss Code of Obligations? In what are they similar and to what extent are they different? This was your task, a comparative analysis focusing on the remedies of the buyer in the event of a breach of contract by the seller. So how do the two systems compare? Let's start by shortly recalling the system of remedies provided for in the sales law of the Swiss Code of Obligations, Articles 205 and 206. In case of non-conformity of the goods sold, the buyer has basically three options. 1. Rescission, which amounts to void the contract. 2. Price reduction. And 3. The delivery of substitute goods, if the sale is for fungible goods. In the CISG, we find this system of remedies. In case of breach of contract by the seller, the buyer has the following options. He can claim specific performance according to Article 46, paragraph 1, which is something that can also be claimed under the Swiss Code of Obligations, obviously. It isn't mentioned in the Articles 205 and 206 of the Swiss Code of Obligations because it goes without saying on the Swiss law. Another option the buyer has under the CISG is claiming the delivery of substitute goods according to Article 46, paragraph 2. But this is only available in case of a fundamental breach of contract by the seller. A third option is claiming remedy by repair according to Article 46, paragraph 3. This is something that is not available under the Swiss Code of Obligations, at least not for sales contracts. It is different for manufacturing contracts according to Article 368 of the Swiss Code of Obligations. Under the CISG, the buyer can also claim avoidance of the contract, but this is more difficult than under the Swiss Code of Obligations because the condition is fundamental breach of contract in the sense of Article 25. A further option is fixing an additional period of time to the seller for proper performance according to Article 47, which is also referred to by the German term of Nachfrist. The advantage of fixing such Nachfrist is that if the seller does not rectify the situation within the additional period of time, the buyer is entitled to declare the contract null and void with no need for a fundamental breach of contract. Finally, there is the option of price reduction, similar to what we have in the Swiss Code of Obligations. So how do the two systems compare? On the blackboard, I have prepared an evaluation grid. Let's start by looking at what is very similar. What is basically the same is that in case of non-conformity of the goods, the buyer has the option of price reduction under both systems. The buyer is entitled to reduce the price in the same proportion as the value of the goods sold is diminished by their lack of conformity. If there was more space on my blackboard, we could also add specific performance that can be claimed under both systems. Furthermore, we could add the basic provisions defining conformity and non-conformity and establishing the duty of the buyer to notify defects to the seller. On the next line, we can note that compared to the Swiss Code of Obligations, the CISG presents a number of advantages for the buyer that correspond to disadvantages for the seller. An advantage for the buyer is that under the CISG, remedy by repair is available, which is not the case for the sales law of the Swiss Code of Obligations. Another advantage for the buyer is that the passing of risk is later, which means less risk for the buyer and more risk for the seller. In addition, what is also very relevant for a non-Swiss buyer is that to the extent to which the CISG applies, there is no need to deal with foreign national law. Those are significant advantages, and if there was more space on my blackboard, we could even add the slightly more generous time frame that the CISG offers for the notifications of defects that the buyer has to make to the seller. On the other hand, there are also some advantages for the buyer corresponding to disadvantages for the seller in the Swiss Code of Obligations. First of all, avoidance is easier under the Swiss Code of Obligations, since there is not the same requirement of a fundamental breach of contract as provided for in the CISG. The CISG makes it difficult to avoid the contract, the idea being to favor solutions that maintain the contract. What tends also to be easier under the Swiss Code of Obligations are claims to the delivery of substitute goods. Again, in contrast to the CISG, the Swiss Code does not require a fundamental breach of contract for this remedy. On the next line, we shall mention advantages for the seller that go with corresponding disadvantages for the buyer, and there are several such advantages to be found in the Swiss Code of Obligations. An advantage for the seller is that he does not have to face claims for repair. In contrast to the CISG, the Swiss Code of Obligations does not grant the buyer any right to a remedy by repair. Furthermore, the risk passes earlier from the seller to the buyer, so that, compared to the CISG, there is less risk for the seller and more risk for the buyer. Another point is that for Swiss sellers, it might be convenient to be able to deal with domestic law in case of a dispute. On the other hand, having to deal with Swiss law is a clear disadvantage for the foreign buyer. If we had more space on the blackboard, we could also mention here that the stricter time frame for the notification of defects protects the interests of the seller and makes it more difficult for the buyer to claim rights for non-conformity of the goods. On the other hand, there are also advantages for the seller and disadvantages for the buyer with the CISG. One of those is that since avoidance is more difficult under the CISG, there is less risk for the seller that he would have to face situations where the contract is successfully avoided by the buyer. Similarly, claims to the delivery of substitute goods are also more difficult to make for the buyer under the CISG. Looking at the balance of the whole comparative analysis, I think it is fair to say that in an overall perspective, the Swiss Code of Obligations seems to be slightly more advantageous for Swiss sellers, whereas the CISG seems to be slightly more advantageous for foreign buyers. In practice, many Swiss sellers tend to systematically exclude the application of the CISG in favor of the Swiss Code of Obligations in their standard contracts, even though the CISG seems to be slowly gaining in popularity as well. Let's come back to our case at this point. If you had to give advice to Y Limited, you would probably recommend to favor the CISG as the applicable law when negotiating the contract. However, if you had to give advice to XSA, you would probably consider suggesting to have the Swiss Code of Obligations defined as the applicable law in the contract. But this is far from inevitable. The CISG also offers a well-suited basis for international sales transactions, and since it is characterized by the principle of party autonomy, it can be adapted to the specific needs and the specific interests of the parties in the individual contract. So as you can see, this is an important question, but there is no easy answer. In the final part of this lecture series, I would like to go into discussing issues. The first issue is related to the interpretation of the CISG. In practice, the CISG is applied and interpreted by national courts and arbitral tribunals throughout the world. There are no specific international CISG courts, and there is no such thing as a Supreme Court of the CISG. This leads to the danger that the CISG, that is meant to provide a uniform set of rules for international sales transactions, becomes non-uniform through interpretation by different courts and different arbitral tribunals in different parts of the world. The American scholar John Honnold defines the problem in those words. The convention, faute de mieux, will often be applied by tribunals, judges or arbitrators who will be intimately familiar with their own domestic law. The tribunals, regardless of their merit, will be subject to a natural tendency to read the international rules in light of the legal ideas that have been embedded at the core of their intellectual formation. The mind sees what the mind has means of seeing. This is called the homeward trend. The CISG addresses that issue in its general provisions. Article 7, paragraph 1 says that in the interpretation of this convention, regard has to be had to its international character and to the need to promote uniformity in its application and the observance of good faith in international trade. This means that judges, arbitrators, lawyers, and business people need to have access to case law from all over the world. They need to know how the CISG is applied and interpreted by courts and arbitral tribunals throughout the world. This is why considerable efforts have been made to put in place a number of CISG databases. These databases include the cloud database provided by arbitral, the CISG online database established by the University of Basel in Switzerland, and the CISG database of Pace University in the United States of America. All of those databases offer a huge amount of resources, case materials, and specialist literature, and everything for free.